Welcome to Landmark Law. My name is Winnie Luck Taylor, founder and principal lawyer of Landmark Law Professional Corporation in Ontario or in Markham, Ontario, Canada. And Landmark Law provides quality and affordable legal services in wills and estates, corporate law, and real estate law. And as part of our Wills and Estates webinar series, we're pleased to present on corporate wills. Before we begin, please read our disclaimer. The contents of this presentation is for informational purposes only and does not provide legal advice or create a lawyer-client relationship with the viewer. So what are corporate wills? Okay. Corporate wills are very popular among medical professionals, but they actually can be used by anyone, okay? And in the case of corporate wills, a single person would have two wills. That's right, two wills. A single person will have what's called a primary will and a secondary will. Okay? The secondary will is also known as corporate wills. Okay? But it's generally the medical professional, they solely use the term corporate will, but it's the same thing. So what is it, and why do people have two wills instead of one will? So traditionally, when you have a single will, like a lot of people do, and when it comes time to your passing, your trustee or the person who manages all your estate or your belongings on your behalf is getting ready to honor your will. This person has to file your single will with the estate office. And in the application to file this will, a process known as probate, in the probate application, it requires that the value of the estate be calculated and taxes be calculated on the value of the estate, and those taxes get paid to the Minister of Finance, okay? All of this gets done, the taxes get paid before the estate office issues what's called a certificate of estate trustee with a will. Issues a certificate of estate trustee with a will. We'll call this probate certificate to the trustee, and then the trustee can go ahead and distribute the estate according to the wishes and instructions in the will maker's will. This is what happens, okay? Now, when there are two wills, what happens is that will number one contains all those estates belonging to the deceased that require the trustee to obtain a probate certificate in order to distribute those assets, okay? So it's restricted to only those estates that absolutely require the trustee to have this probate certificate in order to distribute this asset. So this would be, a good example would be bank account. So if the trustee were to approach the bank and present a copy of the death certificate and the original will and mention that here's our death certificate, the account holder at your branch has passed away, and in this will, I'm the trustee and I'm here to distribute the funds in the bank account according to the wishes in this will. The teller is going to ask the trustee for a copy of the probate certificate proving that the trustee has that authority. So the will's not good enough. The trustee must present a probate certificate. And as I mentioned, the trustee must file a probate application, pay taxes in order to get this probate certificate. Okay. However, for will number two, Will number 2 contains, or secondary will or corporate will contains those assets that do not require an estate trustee to present a probate certificate to anyone, okay? And if no probate certificate is required, that means no probate application or probate process is required. And if no probate process is required, no estate administration taxes on those items in secondary will are required. So you might ask, why does this happen? Why do we have some items that are subject to taxation or require a probate certificate, such as the example with the bank? And why would there be some items that do not require a probate certificate or taxation in order to distribute those assets? Well, I'll give you a really good example. Imagine this was a painting or piece of art. So if I'm a trustee and the owner of this art has passed away, and in the will it mentioned what to do with the different personal belongings, well, this piece of art is not registered with anyone. I don't need to approach anyone to get permission to distribute it to the beneficiary. I'm the trustee. I have authority to go ahead with the distribution. No one's preventing me from distributing it. I can take it and under the instructions of the will, go ahead and give it to the beneficiary, who will now become the new owner. So there are items that don't require a probate certificate to distribute. There's many items, in fact. So why necessarily would business owners, medical professionals, or anyone be particularly interested in this? So the other name for secondary will is corporate will. And in particular, business owners and people who own shares of private companies are able to distribute private shares without the need for a probate certificate, and hence need to pay the estate administration tax. So again, if I'm the trustee and the deceased were to have a medicine professional corporation, I could transfer the shares to the beneficiary, and I don't need to go to any broker or financial institution and get permission or show my probate certificate in order to distribute this private share. And if I do not need to present a probate certificate, again, I don't need to have the estate pay any estate administration tax or probate fee on the value of these private shares. So you might wonder, why are we so lucky? So if the deceased had investments in stocks, publicly traded shares, and the trustee had to go to the bank, and the bank of course is going to ask for the probate certificate, why do we have this difference? Why did the law require that shares in private companies require a probate certificate for the trustee to distribute it, and shares in private companies, such as private businesses, different health corporations, don't need it? There's actually a loophole in the estate legislation. There's actually a loophole. The state legislation is silent. It expressly mentioned that shares in publicly traded companies, or shares listed on a publicly trade in a stock market, okay, required a grant of authority. That's the fancy word used, which means probate certificate. And it was silent. It was silent on private shares of private companies. Okay. So, and this is a loophole contained in Ontario estate law. It's not available in the rest of Canada. So Ontarios can enjoy this strategy. And I did mention that it's not only owners of private businesses that can enjoy this strategy of separating out your estate from those that need taxation in the primary will and those that do not require taxation in the secondary will. Anyone can enjoy this. Anyone. And I mentioned the art example. Okay. Because it also applies to inventory of possessions. So let me explain. Your estate contains everything that you own alone at your death. Your car, bank account, clothes, jewelry, business interests, etc. Okay? So we can see already in that list, clothing, jewelry, right? These are personal belongings that the trustee doesn't have to approach any organization or a brokerage or agency and get permission before distributing those. These are just assets that are clear and readily transferable, readily transferable assets. Okay, and a lot of people own a lot of these types of items that are free, clear, and transferable, right? These plants here, this camera here, this television monitor artwork, that hybrid item here. These items don't require permission. They're not registered anywhere. Okay, so those items can go in the secondary will. And you might ask, well, if no one's keeping track of them, then why do I have to even, if I had one will, why do I even have to value it anyways? Why can't I just leave it out? Why do I need to put them in a secondary will? Well, when you pass away, your state has to file its last tax return, and it also has to file what's called an estate information return. This is a recent requirement, okay? It's fairly recent, and in it must detail an inventory reflecting everything in the estate, and it's subject to an audit, and there's a continuing duty to report any changes in the estate value. So I mentioned right at the beginning of this webinar that the trustee, if you have a single will, has to prepare the probate application with a lawyer and calculate the value of the estate and calculate the estate administration tax, based on the value of the estate. And so it has to match your estate information return, and the estate administration return is subject to an audit. So you have to be truthful about it and include in your single will both items that would be subject to probate and those that would not be subject to probate. Okay, so, and if you have a single will, you have to pay taxes on both types of items, regardless of whether or not a probate certificate is required, because if it's reported in a will and that will is the one that's filed, then taxes are paid on those items in that single will. Okay, but if you have the two wills, you're allowed to separate them, and you're allowed to include only taxable items in primary will and non-taxable items in secondary will, and record the total value in the estate information return, and in the probate application only record the value in the primary will. I know that's a mouthful, okay, but you can rewind and play that again. And basically, you have to account for everything in your estate administration return, and you have to account for everything either in one will, where you're going to pay tax on everything, or two wills, where you're going to pay tax on some items and not the other. And in the second will, you're not going to pay taxes on those items. Okay, I think you got it. All right, so that brings us to the end of our webinar. We commonly get asked what our fees are. Our website is www.landmarklaw.ca, one word, landmarklaw.ca. And in our left side menu, we have a link to cost calculator. And here you can get the cost for our basic will. Okay? You do have to email us for the pricing for the primary and secondary wills. We understand your circumstances a bit more. We have client kits so that you can get started. Again, left-hand sidebar, click client kits, and you can click the one on wills and powers of estate. It contains questionnaire and compliance form to verify your ID and our retainer agreement. And if you enjoyed our presentation, we would appreciate a 5-star Google review. Google Landmark Law, click write a review, or you can see the direct link that I have provided. The easiest is Google Landmark Law, write a review. During COVID-19, we are offering social distancing signing under many methods. Okay, we've got remote, virtual counterparts. Okay, these are all allowed during this COVID-19 time according to emergency orders by the Minister of Finance and Law Society of Ontario. But the most popular method that a lot of clients have been applying is signing on our outdoor patio. So that's a picture of our outdoor patio. Okay, and none of the germs are contained anywhere, and we have disinfectant wipes, hand sanitizer, we wear masks, we ask you to, and you don't have to touch any surfaces as we open the gate for you to come into our outdoor patio. Great. Well, we thank you for attending, and we look forward to seeing you in the next webinar. Please like us on facebook.com/Landmark Law PC, Landmark Law PC, to watch our other videos. Thank you. Take care.